Shalom, this is Yah is Magnified, and I'm back with another informative video. Today's video is titled, Rick W. Never Won Child Support. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth, nothing more, nothing less. So with that being said, I would like for you all to hit that like button, and also, if you're new to my channel, hit that subscribe button, and also hit that notification bell so you all can be notified as I'm dropping these power videos. So without further ado, let's get to it. Okay, so in this video, I will be exposing the fact that Rick W. never won his child support case despite what he wants you all to believe. Okay, so what we have on the screen is his video, right? And in this video, he titles it, My 1 Year Anniversary Getting Off Child Support. So, according to him, he's been off child support for 1 whole year based off this order that he has on the screen, okay? So, we're going to go over this order, but before we go over this order, I just want you all to hear him state that he's been off of child support for 1 whole year ever since this order right here was created. And we're going to find out, is that true or is that false? And if it is false, then Rick W., you got some explaining to do. You have to now show proof that you actually got your case dismissed. Okay? So, without further ado, let's listen to him. Let's hear him out, guys. Let's hear him out. Let's listen to him.
Today is 1 year ago that the judge issued an order vacating my support order. 14 months later, and vacating arrears of $40,000. Okay, so it was a year ago, and I didn't realize it was vacated until a week later. So I went to court. They gave this to me, and he did this like towards the end of the order. And you know what they do is they put all this stuff in there to make it look like they're doing something. All right, but he was covering up, and he put this towards the end. So when I first got it, I just read the beginning of it, and I was like, this is more of that bullshit. So a week later, on the 23rd, which is the day before Thanksgiving, and the day that this video was made here, I was actually going to go to court, and I decided to read the whole thing over, and I realized that, oh, it's over. And that was the reason why the judge had me go to court. I went to court on the 16th, and when I got there, the court officer says, oh, no, you don't got to go to court. The judge wanted you to have this. And he handed me the order in an envelope. So like an idiot, I'm walking around for a week, not knowing that my support was vacated.
Okay, so you guys heard that. He simply said what? He simply stated that it's been a whole year since the judge vacated his child support order. So he's making it appear as though this order that he had got vacated dismissed his entire case. Okay, he even came back on here to celebrate it a whole year later, guys. So I'm going to show you all what you're up against when you're dealing with these individuals online. So now let's go to this actual video. You all can see upper right hand corner. The title of the actual video is called Child Support Order is Vacated. It's over, Johnny. It's over. So again, he made it seem as though that his child support situation was completely over because he received this document or this order on the screen. So now let's go to the original video, guys, and hear him out. Let's listen in again. So this time we're going to go to that actual video that he placed from the beginning, the same video that he was talking about in this video. So let's go there. Okay, so this is the initial video that he made the anniversary video about. So in that video, he stated that his case was over with for a whole year. According to him, he titled this video, Child Support Order Vacated, It's Over, Johnny, It's Over. So he's trying to make it seem as though he's no longer on support. So we're going to find out if that statement true. So now let's play the initial video. Let's break this thing down and let's get to the bottom of it. Let's get to this truth. Let's get to it.
So what happened was I pulled the order out. I started reading it closely. Okay, get ready. Moreover, the court notes that these matters are generally favored to be resolved on the merits. For these reasons, the court finds it is appropriate to vacate decision and order of support issued by support magistrate on September 23rd, well, it was really the 24th, I think he got it wrong, and September 24th, respectively. Guess what, guys? He finally vacated my support order. It's over, Johnny.
Okay, so now, as you all heard from him, he clearly stated that what? That the case is vacated and it's over Johnny. So he's making it seem as though that order or that one sentence vacated his entire support order, which is incorrect, guys. Okay? To further prove that, let's just read the bottom section. After the highlighted portion that he didn't read, it states what? Accordingly, this matter is remanded for a hearing pursuant to Judge Lubo's order upon notice to all parties before the support magistrate. So again, guys, he didn't want to read that sentence. But in the video, he did read it by mistake. And let's see what happened when he read it by mistake. Let's see how he started to stutter when he noticed that he shouldn't have read that line, because that line basically exposed that something was vacated, but it wasn't his entire order. Because if it was his entire order, he wouldn't be going back before the support magistrate for another hearing. Okay, so now let's go back and hear him explain that as well. Let's go there.
But look at that, guys. For these reasons, the court finds it appropriate to vacate the decision. And accordingly, the matter is remanded. So I'm supposed to go back and have another hearing, but
Okay, so you all heard it from him. He simply said what? That he have to go back one more time. But hold up. He just said it was over Johnny. So if it was over Johnny, that means you won't be going back. So the reason why he's going back, guys, is because the support order that was vacated was a modification order, not the actual order. So they only vacated the modification order and simply going to bring him back to redo the modification order on the merits, okay? To further prove that, let's read some of the order so you all get better understanding of what's going on. So now let's go back to that order again. Let's read it again so you get better understanding. Okay, so I have a screenshot of the actual order from his video. So I apologize for the blurriness, but I believe all that was done strategic as well. Because when he wanted to show the highlighted area, he made sure that was clear. But for the rest of the order, he made sure it was blurry so we couldn't barely read it and make out what it says. So this is the most clearest photo that I can get of the entire third paragraph. I have other clear photos, but it's not of the third paragraph in its entirety. It breaks off certain sections of the third paragraph. So again, I apologize because it's blurry, but I can make it out and I can read it, and we're gonna all read it together. So now let's pick it up in the third paragraph where it states and it reads, the determination of whether to relieve a party of an order entered upon his or her default is within the sound discretion of the family court. Case law to support that. Then it reads, although the respondent did not specifically set forth a meritorious defense, so stop right there. Who is the respondent? The respondent is Rick W. So it states basically because Rick W didn't set forth a meritorious defense, then the court is going to vacate the order issued by the support magistrate, which modifies his original support order. So they only vacated the modification order, and then they're going to bring them back in to have a rehearing of the same issues on the merits. To further prove that, let's continue reading. Then it states, again, let's read it again. Although the respondent did not specifically set forth a meritorious defense to the allegations in the petitioner's enforcement petition, the court is constrained to grant the respondent a certain degree of latitude since he is representing himself and has been actively involved in the exclusive litigations in this matters. Moreover, the court notes that these matters are generally favored to be resolved on the merits. So again, guys, because this case was not resolved on the merits and was just issued in, the higher court, which is the court that signs off on the support magistrate's orders, had decided to vacate that order because they want to have a hearing on the merits. Okay? To further prove that, let's read it. It states, for these reasons, the court finds that it is appropriate to vacate the decision and order of support issued by the support magistrate on September 23rd, 2014, and September the 24th, 2014, respectively. And right after that, guys, right after that, it states what? Accordingly, this matter is remanded for a hearing pursuant to Judge Lubo's order upon notice to all parties before the support magistrate. So again, guys, if they vacated his entire order, then why do he have to go back again before the support magistrate? The reason why he have to go back again before the support magistrate, because they're going to have the same hearing again, but this time it's going to be on the merits. What does it mean to have a hearing on the merits? Let's go to Cornell Law School to get a better understanding of that. Let's go there. Okay, so now, as you all can see, we're coming from Cornell Law School. Let's pick this up where it states on demerits. And it reads, the phrase on demerits refers to a case whose decision rests upon the law as it applied to the particular evidence and facts presented in the case. This is in opposition to cases whose decisions rest upon procedural grounds. The distinction between the decisions that rest on the merits rather than on procedural grounds is important because a decision on the merits is considered final and is thus bound by what? By res judicata, meaning once ruled upon, cannot be ruled upon again. That's why they want to do it on the merits. So once they rehad the hearing on the merits, there's another order out there. But you notice Rick W is only talking about this same order, and it's for a reason. Why? Because he can make you all believe that he actually had his actual case vacated. No, he only had the modification order vacated. His initial order is still intact. That's why you have to go back again to have the hearing on the merge in front of the support magistrate. But let's continue. Then it states, if a decision is bound by res judicata, the parties involved in the case may not later raise those same claims in a subsequent case. Instead, a party that disagrees with the decision must what? Must appeal the decision, file a motion for a new trial, or file a motion to reconsider. Decisions that do not rest on the merits, however, are not bound by res judicata because the claims were not properly heard. Thus, these claims may be brought forth in a subsequent case, excluding dismissal due to what? Due to failure to state a claim. So you can bring it up, but you can't bring it up for failure to state a claim. Basically, that's all it's saying. But to have a hearing on the merits is just simply having a hearing on the facts and evidence presented into the court. And once those facts and evidence are established, then once that order is issued, then you cannot go back and challenge that order unless you file an appeal, a motion for new trial, or a motion for reconsideration. That's it. That's all. So in this case, because the hearing wasn't held on the merits, the court simply vacated the motion modifying the original support order, which placed the original support order back in effect, and then they scheduled another hearing on the merits before they can address the arrearages and everything else. Why? Because at the time of these orders, his child was 25. I mean, one of them was 22, and the other one was 19, I believe. And we're going to go over that as well. So let's continue breaking this thing down, and let's continue applying pressure. Time to show who's real and who's not. Let's go. Okay, so again, let's go back and read the order. And it reads, highlighted area, it states, for these reasons, the court finds that it is appropriate to vacate the decision and order of support issued by the support magistrate on what? September the 23rd, 2014 and September the 24th, 2014. So now let's go over the September the 24th, 2014 order to see what that order states. Let's go there. Okay, so now, as you all can see on the screen, is in fact an order modifying an order of support. This is the same order that was modified or that was simply vacated because it was not issued on the merits. As you all can see, all the Rick W information right there. Okay, you all can see, again, those are his children. Okay, his two children. One of them was 22 at the time of this order, and the other one was 19 at the time of this order. So both his children are adults during this time, and he's still paying child support for them, guys. Okay, to further prove that, now let's go to the last page so I can show you the date that the judge signed this order so you all can see that this is in fact the September the 24th, 2014 order. Let's go there. Okay, guys, so now as you all can see on the screen, this is the last page of the 2014 order. As you all can see, September the 24th, 2014, exactly what it states in the order that he put up on the screen. So this order, which was the modification order, that order was vacated, not the actual case. To further prove this, guys, let's just do a simple Google search that's basically asking Google if a court vacates an order to modify a support order, does that order vacate or terminate the entire case or dismiss the case? Let's go and see what Google has to say or AI has to say about this. Let's go there. Okay, guys, as you all can see, a simple Google search, I just simply typed in New York judge vacated an order to modify child support. Does that dismiss the entire case? And AI states what? No. A New York judge vacating an order to modify child support does not automatically dismiss the entire case. Vacating an order voids that specific ruling, but the underlying child support case typically remains open and reverts to the last valid order. Same thing I was telling you guys. So, because they only vacated the motion to modify or the order modifying the support order, now the original order is still in place. That's why you have to go back down to the court to have everything ruled on the merits. So, in all actuality, Rick W. never won a thing, guys. When I tell you guys that these men haven't won a thing, they haven't won a thing. I'm not here to lie to you all. I'm here to bring the truth. The truth shall set you all free. But let's continue. Then it states the effect of vacating the order. Original order reinstated. When the modification order is vacated, the original child support order, the one that was in effect before the attempt to modify it, is reinstated. The parties must continue to follow the terms of that previous order. Again, so he never won anything, guys. He is still in that original order after they vacated his the modification order, and then they had another hearing after that. As you all notice, he never mentioned that hearing after that. But let's continue on. I'm about to show you guys who people was going to for help, and this guy couldn't even help himself. But let's continue. It states, case remains open. The vacating of the modification order does not end the entire case. The original child support case is still active, and either party can file another petition for modification in the future. So again, guys, that's why the judge remanded it back down to the support magistrate to have a hearing on the what? On the merits. So he never won the case, guys. But let's continue. Case continues. Depending on the reason the order was vacated, the judge might order a new hearing to reassess the evidence or allow the case to proceed with further argument. That's exactly what happened. So that's why they vacated it, sent it back down to be ruled on the merits. And once they ruled on the merits, there's another support order issued in. So now Rick W. have to let us know or show the order of the case being dismissed after he had that hearing that the judge vacated the order, sent the case back down to the support magistrate. Let's see if he showed that. I guarantee you guys he will not. Why? Because he's still on child support and he haven't won a thing. But let's continue. Then it states, uh, different from dismissal. A vacated judgment nullifies a specific ruling, while a dismissed case is thrown out entirely. Since vacating a modification only affects that single change, the case as a whole is not dismissed. Again, guys, you all been lied to. I told you all he never won a thing. But let's continue. Then it states, common reason for vacating an order. A judge might vacate a child support modification order for reasons such as default judgment. The order was issued because one party failed to appear and that party has a reasonable excuse and a good defense. Procedural error. The court or a party failed to follow the proper legal procedures, such as properly serving notice of the hearing. Mistake or conduct. The evidence shows that the order was based on a mistake or that there was fraud or misconduct by the other party. Last one, lack of jurisdiction. The court did not have the legal authority to make the ruling. Then it states what to do next. Then it reads, if a child support modification order was vacated, both parties are bound by the last valid support order. If a party still seeks a change, they must file a new petition for modification with the court. That's why, again, guys, the judge remanded it back down to the support magistrate to have a hearing on the merits. Okay? So now let's go back and finish listening to his video because I'm about to blow y'all mind at the end. And a lot of you guys should be upset once you hear this. But let's continue on. So now we're back on this video. So I'm going to press play again. But watch me to get to the last line where it states, accordingly, this matter is remanded. When he read that, he's going to pause. Why? Because in his mind, he knew he shouldn't have read that. But he's going to pause and he's going to try to explain himself out of this. And it's going to get worse for him after that, guys. So let's listen in.
Look at that, guys. For these reasons, the court finds it appropriate to vacate decision. And accordingly, the matter is remanded. So I'm supposed to go back and have another hearing. But here the judge took care of me one more time. What happened was, this has been going, like, you know, I don't want to go. I've told you guys, you know, I'm stuttering because I'm a giddy fool right now, right? I'm giddy.
Okay, so again, as you all just heard him, after he read that last sentence, once he got in the middle and he realized what he was reading, he automatically stopped, tried to explain himself, started stuttering, talking about he giddy, trying to make it seem as though he happy, but he really didn't do anything, guys. The only thing the only thing the judge did was vacate the support magistrate's orders for modification. That's it. That's all. The original support order is still in place. That's why they have to go back for another hearing on the merits pertaining to the modification of the support order. Where is that order at, Rick W., after the second hearing? But what's going to really put the icing on the cake, guys, is this last portion I'm going to share with you all. And after that, I'm going to let you guys go. But this is going to be a shocking to a lot of you guys. But the truth is the truth, and the truth will set you all free. I come to only bring the truth. I'm the only person that comes on here saying all my videos are all facts, all truth, all proof. Nothing more, nothing less. No one else comes on the internet and say these things. So let's hear out the last little bit of the video, because he's about to really expose himself right here. Let's get to it.
I have a stipulation settlement agreement, and it was supposed to be readjusted in case I went back to work. I never went back to work. I retired. So this support magistrate was so vicious because the judge, the other judge, not the judge that took care of me, the past judge who retired, she told her to do a de novo, DENOVO, which is some Latin term for do-over, basically. That's really, de novo, do-over. It kind of sounds the same.
Okay, so as you all heard, he went before another judge, and the other judge told him that he have to do a de novo, which simply means to redo. To redo what? To redo the order for modification. And it's just that simple, guys. But let's continue on. This last bit of the portion is going to hurt a lot of you guys' feelings, guys. I'm going to be honest with you. But the truth will set you all free. Let's continue to expose these cats. Let's get it.
That's really, de novo, do-over. It kind of sounds the same. And so this vicious Sudeep Kaur, she's so vicious and incompetent. She's like, well, she told me to go back 2007, but it was always supposed to be based on earnings. Earnings are when you work. The definition is right in the IRS. It's wages. So the judge took care of me here to be readjusted. The amount of child support would be computed based on CSSA and respondents' earnings. So he put that in there to protect me.
Okay, so now, as you all just heard, he simply stated what? That the order should be entered based off of earnings. But hold on. You said it was vacated and it was over Johnny. So if it was vacated and it's over Johnny, then why must the order be based off of earnings? Simple. The order must be based off of earnings because they only dismiss what? The motion modifying the support order. That's it. That's all. Not the actual case. That's why they sent them back down to another hearing before the support magistrate again to have the hearing on the merits and not on procedural grounds. See, the first modification order was issued on procedural grounds. So the judge vacated and said, hold on, go back and do it on the merits. So after they ruled on the merits, then it becomes a final order and is barred by res judicata. Only how you can fight the order is through appeal, motion for reconsideration, or motion for rehearing. And it's simple as that, guys. But hold on. We about to end it with a bang. So, let's hear him out for the last time, guys. Let's hear him out. I'm going to let y'all go with this. I know a lot of y'all going to be upset, but I'm going to let y'all go with this. Let's get it.
So he put that in there to protect me. So I'm supposed to go back to court on December 6th.
Hold up. Hold up. Did you guys just hear that? Again, did you guys just hear that? What did he just say? Again, what did he just say? He said he had to go back to court on December the 6th. But hold up. I thought the support order was vacated and it was over Johnny. So if it's so-called over Johnny, then why are you still going to court on December the 6th? I'll tell you exactly why, which is the same reason why we went over. Because the order only vacated what? The order only vacated the modification order. That's it. That's all. Once the modification order was vacated, it reinstated the what? The initial order. So once the initial order was back reinstated, the judge remanded the case back down to the support magistrate to have the support magistrate redo the modification hearing, but this time on the merits. So after they did it on the merits, then that would become a final order and he can only attack that final order by what? By filing the appeal or by doing a motion for rehearing or by doing a motion for reconsideration. That's it. That's all. The guy never won a thing, guys. He's been bluffing the whole time. So, Rick W., show that December the 6th order, that December the 6th, 2014 order, proving that you went in there and handled your business. But you wouldn't do that. You know why? Because what you said next is the nail in the coffin. Let's get it, guys. I'm telling you, these guys cannot help you. They didn't even help themselves. Let's prove that, and that's in the video right here. Let's do it.
So I'm supposed to go back to court on December 6th. And I'm going to be honest with you guys. I always tell you that I am getting an attorney. I have to.